Good evening, everyone. Welcome to the University of Melbourne this evening for the 2026 Jim Carlton Integrity Lecture. My name is Kristen Rundle. I'm a professor here at Melbourne Law School. I'm your chair this evening. And as your chair, it's my privilege to acknowledge the country we are meeting on this evening at the University of Melbourne, the unceded lands of the Wurundjeri people of the Kulin Nation. I pay my respects to their elders past, present and emerging, and extend those respects to any Indigenous persons who have joined us this evening. A little bit of housekeeping before we get going with tonight's event. These proceedings are being recorded, and as soon as it's available, a link to that recording will be emailed to all people who registered for tonight's event. So make sure you look out for that. It's also being photographed. If you have any concerns about that, Emily, our events officer, please just see her at the end of the lecture. And of course, could I ask you that you all put your mobile phones to either off or do not disturb for the duration of the lecture. We'd appreciate that. Thank you. We meet tonight for a very important annual public event here on the Melbourne Law School and Accountability Roundtable calendars. It's the Jim Carlton Integrity Lecture. Melbourne Law School has partnered with the Accountability Roundtable for now many years to host this public event dedicated to questions of integrity in politics, parliament and government. These matters of integrity lie at the foundation of why the Accountability Roundtable was established. The ART is a non-partisan group of citizens from diverse backgrounds who share a common concern for the erosion of honesty and integrity in Australian democracy and who are dedicated to improving standards of accountability, probity, transparency and democratic practice in all governments and parliaments in Australia. 10 years ago now, in 2016, the ART renamed their annual Integrity Lecture to honour the Honourable Jim Carlton AO, who served as an active ART board member prior to his death in December 2015. We are delighted that we have with us tonight Jim's widow, Dal Carlton, as well as his daughter Freya and his granddaughter Claudia. First grandchild appearance, I believe, so far. Jim Carlton was born in Sydney in 1935 and over the course of his life had several careers as a management consultant, a Liberal Party official and as a federal politician from 1977 to 1994. During which time he made important contributions to changing the direction of economic debate in Australia, most notably by embracing the global economy and rejecting tariff protection. During his tenure in the Commonwealth Parliament, Jim Carlton held positions including Minister for Health and Shadow Minister in portfolios of Treasury, Education and Defence. He went on in his post-parliamentary career to continue his extraordinary record of public service by becoming Secretary-General of the Australian Red Cross, from whom he received that organisation's highest international award, the Henri Dunant Medal. As a parliamentarian deeply committed to open government and the highest levels of accountability, Jim Carlton embodied the principle to which the Accountability Roundtable is dedicated, namely that public office is a public trust. Tonight's lecture is a particularly special one for both Melbourne Law School and the Accountability Roundtable because it addresses a topic, government unaccountability in the digital age, that goes to the heart of why the ART was formed and demonstrates how and why its concerns are reborn anew in each generation of public power and public life. I'd like now to hand over to the chair of the ART, Robert Redlich, AMKC, to introduce our presenter, Professor Anne Twomey.
Thanks, Kristen. I can avoid saying much that I was going to by way of introduction. Thank you for your introduction. Art, as Kristen has said, is dedicated to improving standards of accountability, transparency and ethical behaviour and democratic practices in government across Australia. This is a pivotal moment for integrity in Victoria and nationally as well. There's a prevailing, entirely justifiable public perception that integrity in government has declined, that the absence of transparency enables executive government to act with a sense of impunity, safe in the belief that there is no prospect that they will be held accountable for decisions that do not serve the public interest. Reforms are urgently needed, and the Accountability Roundtable will continue to press for them. One way in which art seeks to contribute to this reform is through this lecture, which, as Kristen has said, honours Jim Carlton, who was a vigorous and engaged director of the Accountability Roundtable and who constantly fought for integrity in Parliament and public life. He proposed and had been the organiser of Arts Government Integrity Lectures. And as Kristen has said, they're designed to emphasise the duty of public trust, to ensure that public officers serve the public interest. Art is proud to continue that tradition by annually hosting a leading independent thinker to address a pressing integrity challenge. In honouring Jim Carlton's legacy, I'm therefore delighted to be able to introduce our distinguished guest speaker, Professor Anne Twomey AO, Professor Emerita at the University of Sydney Law School. Professor Twomey has had a distinguished career as a practising solicitor, researcher for the High Court of Australia, as Secretary to the Senate Legal and Constitutional Committee, Policy Manager of the Legal Branch of the Cabinet Office of New South Wales, consultant to various government bodies, and as a distinguished academic. She is recognised as one of Australia's foremost authorities on constitutional and public law, and engages in public education through the media and in her YouTube channel, Constitutional Clarion. She has a strong interest in government integrity, anti-corruption measures and electoral integrity. The issue of effective access to important information is one of the defining accountability questions of our time. And it's opportune that Professor Twomey will focus today on no paper and no trail. Given her depth of knowledge of the workings of executive government, Professor Twomey is well placed to address the challenges faced in the digital age by those seeking access to important government documents. Her videos on the Constitutional Clarion YouTube channel on topics such as, quote, "Stop the Shredders, a win for freedom of information," and, quote, "Freedom from information, perpetuating government secrecy," reflect a present disappointing reality about the impediments to transparency. The latter video, she commences by observing that the present Albanese government, like a long line of governments before it, has defaulted to secrecy on achieving government. This default position of whichever party is in government highlights the importance of having an effective freedom of information process. ART is presently developing a policy for the forthcoming state election aimed at addressing the challenges to freedom of information. And Professor Twomey's observations this evening will undoubtedly shape ART's thinking on the reforms that are necessary. Please join me in welcoming Professor Twomey.
Thank you very much. It is a pleasure to be here this morning. Sorry, not this morning, this evening. It's been a long day at my alma mater, law school. Although I have to say, when I was there, I was not in such a snazzy building as this one. I remember, for any of you who do, the old upper law theatre where you'd plonk into the chair and it wasn't properly screwed down and you'd go flipping over the back. So, from an occupational health and safety point of view, this lecture theatre is much better. Anyway, on to my talk. History is written by the victors, it is claimed, but it's also found in the official records of the time. Now, this requires three things. First, that the records are made. Second, that they are kept, and third, that access is granted to them without undue limitations at the appropriate time. And we have deficiencies in all three in Australia. Tonight I'm going to focus on the problems of the absence of records and disappearing records, and then a little bit about how access to such records is subject to throttling by a number of means, including insufficient funding to the National Archives, a culture of secrecy in the public service, attempts to limit access through FOI, or to gut what is released so that you only get the dross and not the substance. Now, while there are many examples that one could choose from of government failures of accountability through inadequate documentation, and the Morrison secret ministry controversy is one that does come to mind, I'm going to focus on perhaps a lesser well-known one, at least here in Victoria, but arguably a more appalling example, and this is from the time of the New South Wales Berejiklian government. As with many corruption issues, it started with the misuse of public funds in a grant scheme known as the Stronger Communities Fund. And the use of this scheme was effectively to favour government political interests. A pre-election funding round was found by the Auditor General to have, quote, lacked integrity, unquote. It allocated 96% of the $252 million in funding to councils in coalition seats. There was no merit assessment of identified projects. The Audit Office found that there was, quote, no documented rationale for why particular projects were funded, nor in relation to the level of funding that was received. Berejiklian infamously responded that pork barrelling was not an illegal practice. She said the community doesn't much like it, but it was part of the political process and it wasn't unique to her government. Well, she was right to the extent that it is engaged in by governments on both sides of politics, but there is also something wrong with it. The misuse of public funds can give rise to criminal offences of misconduct in public office or findings of corrupt conduct. What's most disturbing about it, however, is just the banality and the normalisation of this form of corruption. Politicians of all stripes simply assume that if they have been elected to government, public money is their money to spend for their personal or political advantage, and that this is the way that the political system works. To the victor goes the spoils. But that's not so. Some New South Wales ministers are currently serving time at His Majesty's pleasure in prison, and Berejiklian herself was found to have engaged in serious corrupt conduct with respect to grants in a different grant scheme, and that finding was upheld by the courts. But let's get back to the issue of the documents. You might recollect the original sports rorts controversy where a Labor federal minister, Ros Kelly, made grant decisions on a, quote, great big whiteboard, which was then later wiped clean. Its successor controversy, Sports Rorts 2, used colour-coded spreadsheets, which were more easily retrieved through electronic systems. But the Berejiklian government took this to a new level. While the decision-making power for the Stronger Communities grant scheme was vested in the Minister for Local Government, all but 2 of the funding decisions were actually made by the Premier and the Deputy Premier. The projects that they chose and the relevant amounts were sent by email from ministerial advisors to the Office of Local Government. That office then paid out hundreds of millions of dollars with no formal ministerial authorisation or any documentation about the basis for the selection of the grants, or even a ministerial signature. The emails were based on what were called working advice notes from ministerial advisors who had submitted projects to the Premier for her approval. The Legislative Council's Public Accountability Committee, in its report on the scheme, noted that, quote, due to the lack of any departmental brief recommending the grants, these working advice notes contain the only record of the reasons for the grants, the policy rationale, alternative options or considerations, the advice of the Premier's personal staff, and the Premier's own advice as recorded on those notes. So, what happened to those documents? They were destroyed. The hard copies were physically shredded, and the electronic copies were digitally deleted. Now, I have to say, the introduction told you that formerly I was the head of the legal branch in the New South Wales Cabinet Office, and I can't tell you how shocked I was that that would happen. Certainly wouldn't have happened in the legal branch that I ran in the Cabinet Office. Claims that this was part of routine document management do not make it any better, because one then wonders about all the other crucial documents recording government decision making that have just been deleted. In this case, however, the destruction was not as effective as intended. Government electronic documents are, of course, all backed up in off-site systems to ensure that they can be reconstructed if there is a data hack. Unfortunately, for people deleting documents, it also means that hiding one's tracks is much more problematic in the electronic age. So in a stroke of genius, the Upper House Committee in New South Wales that was inquiring into the grant scandal issued an order for the documents in the backup electronic files. The deleted files were recovered through a forensic IT search and provided to the Parliamentary Committee. So despite the deletion, the material was resurrected. The destruction of the documents, however, also led to an investigation by the State Records and Archives Authority. In its report, the authority noted that compliance with State Records Act ensures that the memory of the state is maintained and is therefore in the best interests of the New South Wales public. Section 12 of the Act requires that each public office must make and keep full and accurate records of the activities of the office. The authority found that the working advice notes relating to the Stronger Communities Fund were required to be kept to fulfil those obligations in Section 12 of the Act, and it concluded that the Premier's office had breached Section 21 of the State Records Act. Section 21 makes it an offence for a person to dispose of, damage or alter a state record. The maximum penalty is a fine of $5,500. Having examined the electronic reconstructions of the deleted documents, the authority found that they recorded recommendations, evidence and justification for decisions or actions of the Office of the Premier and were in effect briefing notes that had to be retained. So, were there any prosecutions? I think you've probably guessed the answer here. No, there weren't. The authority said that its preferred approach was education. It observed that prosecuting people for unauthorised disposal of state records is a labour-intensive activity that is almost certain to bring no improvement to record keeping or commitment to improving practices. Well, maybe, but it cannot help good record keeping practices for public servants and ministerial advisors to know that there is no effective enforcement or punishment for breaching the law. The only effective punishment for ministerial advisors in this case who had destroyed the documents was public embarrassment. The Audit Office, in its review of events, joined the dots between integrity and the lack of documentation. It said, quote, "We cannot rule out the lack of information about accountabilities in the program guidelines, coupled with a lack of formal documented approval from the former Premier and Deputy Premier, was a purposeful attempt to avoid transparency and accountability over the involvement of the former Premier and Deputy Premier in approving grant allocations, Remember, they were not actually allocated the power to make these decisions to begin with. They were doing it surreptitiously behind the scenes through these emails. The Audit Office went on to say, deficient record keeping and program guidelines have meant in practice that no person involved in the grant allocation process is specifically accountable for the decisions about the grant allocations, unquote. The integrity problems with grants under Berejiklian eventually did catch up with her. An ICAC inquiry later made findings of serious corrupt conduct against her in relation to other grants, resulting in the end of her political career. Proper record keeping, greater transparency, and the use of public funds in the public interest, rather than for political advantage, would have saved her. Scott Morrison might also wonder whether greater transparency, including the publication of documentation about his self-ministerial appointments, would have also saved his reputation. While proper keeping of records may seem a rather boring and insignificant detail that can be swept aside in the midst of a busy political life, it is intimately tied to government transparency, accountability and integrity. And this means that it may be critical to the preservation of political careers and reputation. So there is a price to pay for neglecting it. Now, moving to the current day, one of the biggest problems is that much of government business, especially ministerial communications, is now conducted by way of messaging apps that can be set to delete all messages within a certain time of their delivery. The result is that there is neither a paper trail nor a digital trail. Again, this has links to integrity problems, particularly in relation to lobbying. According to an article in the Saturday paper, the Albanese government was, quote, privately urging industry groups, peak bodies and major lobbyists to move sensitive reform proposals off official channels and into disappearing messages on encrypted messaging platforms, a practice that places key policy documents beyond the reach of freedom of information and that may be unlawful, unquote. The paper also reported that multiple sources had told it that they had been advised to submit reform ideas and suggestions on how to amend existing legislation via Signal, an encrypted app, or disappearing messages, and to avoid putting substantive proposals in emails so that they are not captured in departmental records. One lobbyist explained that the government was engaging in consultation on contentious issues like gambling advertising, but was using encrypted or disappearing messages to attempt to avoid records that could be revealed through FOI. Even minutes or summaries of these lobbyist meetings that had previously been given by email were now being given verbally to avoid that problem. Participants were discouraged from providing background material in writing, even when complex technical reforms were involved. Now, this approach leads to three problems. First, there's a problem that reforms can go off the rails if they are based on word of mouth, disappeared messages or communications that never make it on the record. The complex technical information that was intended to inform effective reforms but was not provided in writing because of FOI fears is probably going to be misinterpreted and badly applied, resulting in poor reforms. Second, there will be no long-term accountability and no one will be able to write accurate histories of what occurred because of the lack of documentation explaining how policies were conceived and the information they were based upon. Third, and most importantly from an integrity point of view, keeping such communications off government records facilitates corruption. We already have significant concerns about the transparency of lobbying and potential undue influence. Using disappearing messages for lobbying can only make things worse, not better. anti-corruption bodies do really need to make this a focus of their work in establishing the structures necessary to prevent corruption before it begins. The Office of the Australian Information Commissioner is already on to this problem and about the usage of such apps within the public service rather than between ministers. Now, it produced a report in 2025 in conjunction with the National Archives, which is also concerned about it, and it addresses this particular problem. It's a 2025 report. It expressed concern that messaging apps are not hosted on government servers and that disappearing messages can amount to the unlawful destruction of records under the Archives Act. Now, after that report was issued in February 2025, we saw in the United States the Signalgate scandal. There, a Signal chat group to which a journalist had accidentally been invited was used to discuss imminent military strikes overseas. The messages were set to delete after certain periods. American commentators claimed that discussing classified operations in this manner using an unmanaged app with disappearing messages violated the Espionage Act and federal records laws. A federal judge also apparently ordered that the records be preserved. Now, one would hope that Australian officials would not be quite so irresponsible. But in any case, the use of messaging apps for communications made in an official capacity needs to be addressed so that important records are retained. Of those agencies that were surveyed by the OAIC about the use of messaging apps, 75% permitted the use of messaging apps, fewer had policies and procedures regarding their use. Only 2 agencies addressed searching messaging apps in response to FOI applications, so clearly this ordinarily is not done, and only 1 agency advised public servants on how messages were to be extracted from the app in order to be put into the record-keeping system. This suggests that in reality these messages are not being formally recorded, which is a great loss to history and transparency and also a great risk to integrity. This is an area in which much more work needs to be done if we are to retain adequate government records in the future, both for integrity purposes and for public accountability and history. Now, even if documents are kept, governments are pretty good at throttling access to them. At the archives level, while the period in which government documents are kept secret has actually been reduced from 30 years to 20 years, which is a great thing, the reality is, at least at the Commonwealth level, that it takes much longer to actually access them, even though they're in the open access period, because you have to request to have the file opened. It has to be reviewed, excuse me, before it is opened. Now, that can take years. I waited more than 8 years for some files to be assessed, and by the time I got access to them, and they actually did contain some quite good and interesting documents, guess what? I had already published the book that I had requested them for. I actually checked yesterday my record with the National Archives, and I still have 2 outstanding requests for the openings of files in the archives that were submitted in 2012. So 14 years I've been waiting for those documents. Frankly, I couldn't even remember what they were, but anyway, 14 years I asked for them. 3 files I'm waiting for from 2020, so only 6 years ago, youngsters, and 4 from 2024. So because of the delay, most people just give up and don't bother. I mean, if you're a serious academic and you need access to, you're writing a PhD or something, you go overseas simply because you cannot guarantee that you will get appropriate access to Australian documents because of this problem with the National Archives. Part of the problem has been long-term underfunding. Another problem is that the archives checks with the relevant government department before it releases the files, and there is absolutely no priority in the public service to get this done. So the files are stuck in the corner of someone's office and they stay there until they die or they retire. Okay, that's what I'm assuming happened to the ones that have been sitting there for 14 years that no one has addressed. Okay, the third problem is also that there is a chronic attitude of secrecy that results in ridiculous levels of redaction or outright denial of access to files. Depending on time, I could tell you some great examples. I'll tell you one little one here. At one point I was looking for, I wanted to get the resignation letters of all the Prime Ministers to see what they say about whether, the extent to which their resignation involves the entire resignation of the entire ministry or not. There's actually a switch over where that happened in about the 1970s. I was denied access to a letter of resignation of a Prime Minister on the grounds that it was personal information and private business issue. And I said, I'm sorry, there can be nothing more public than a Prime Minister resigning. Like, it's not secret. It can't possibly be personal and confidential. I mean, what did he do? Did he scribble something rude in the corner? Because that's the only thing I can imagine. So in the end, we did a compromise, and the compromise was they would read out the letter to me on the phone. I couldn't see it, which is why I had this assumption that maybe he drew something rude in the corner. They would only read the letter out to me. And the letter that they read was the exact standard form one that the public servants had written and copied for the last 20 years. So who knows? But anyway, in terms of ridiculous FOI responses, I've got a million of them. But anyway, I will run out of time if I keep doing that. Okay. Oh yeah, so the other one that quite annoys me is that I was denied files, this is under the Archives Act. They were well outside the confidentiality period, so they were 40 to 50 years old, concerning the application of the constitutional provisions for the disqualification of MPs. Now you might remember all those MPs accidentally finding themselves disqualified under section 44 of the Constitution. If you actually go looking in the archives, there's a whole lot of files about previous times when people have raised these issues of, am I disqualified if I'm an Irish citizen or whatever. But they won't let you look at them, will they? Even when they're outside the period of confidentiality. Why? Because there are some legal opinions on there. I mean, this is just completely bonkers because apart from anything else, since those things had, legal advisors upon them 40 or 50 years ago, there have been a few cases which have reinterpreted the law, Sykes and Cleary and a whole lot of other ones. So nobody could trot up to the High Court and say, oh, well, the law's completely different because of an opinion 50 years ago. So why are they hiding them? Okay, it's completely and utterly counterproductive, but this is the kind of rubbish you get when you start looking for documents. The culture of secrecy is intense. With FOI, the delays aren't quite as bad as with the archives, but they're not terribly timely. The main problem in FOI is the excessive and often inappropriate use of redactions and exemptions. So you'll get back documents, but they'll just be pages and pages of black. In the very early days of doing this, much like the stuff about getting the tapes and reconstructing it, in the early days, I was once, when I was a secretary of a Senate committee, some bright sparks who got the redacted things went to a place where they could digitally remove the redaction and see what was underneath, and then rocked up to the Senate committee and said, this is what they're hiding. They got much better at redacting after that, but it was very entertaining at the time. Okay, so the government, while enthusiastic about FOI reform to improve openness and transparency when it's in opposition, is not so enthusiastic now. It recently proposed FOI reforms which would have made access harder, imposing application fees, which indeed a previous Labor government had got rid of, and expanding the scope of exemptions, particularly for cabinet documents, because they're absolute exemptions, and also for the notorious deliberative processes, which might mean virtually anything. Again, one of the biggest problems is the culture of secrecy. No one wants to release anything lest it embarrass the government and get them into trouble. Maybe a better approach would actually be to release documents by default after a certain period of time, unless the relevant agency can establish within 30 days or whatever that there is an overriding interest in maintaining their secrecy. I mean, there are still good reasons to keep some documents secret. National security, for example, is a really good reason, and there are others. I mean, I am a public servant, or have been a public servant, I should say, in the past, and I am sympathetic to that. And also, I can understand the government's concern that while they are in the course of doing sensitive negotiations, they don't want them to be disrupted by an FOI application that reveals that they've been thinking about certain things that puts the whole issue off the rails. I get that. Maybe you just need to say in certain sorts of cases where it's something that hasn't reached a resolution yet, you don't get your FOI for 6 months or a year or something. That would be perfectly reasonable, but it's not a good reason to exclude people completely from seeing those kinds of documents. We just need to be more focused on making sure that on the one hand, governments can reasonably operate, but on the other hand, members of the public can reasonably have access to the information that calls government to account. That needs to be balanced, and it shouldn't be an extreme one way or the other. It is true that the government faces a genuine problem with floods of FOI requests, and again, technology has been aiding this recently. So AI, for example, has made it much easier to put in requests to every single government agency for this, that and the other. And it has led to people exploiting the system, doing phishing requests to see what every single agency is spending on pot plants or whatever, just to get an article to say, ooh, this particular agency is spending double everybody else is on pot plants or something or other. That sort of stuff is wasting people's time. Now, I remember from running a legal branch, I actually administered the FOI Act in New South Wales when it was called that. It's now called GIPA, just to confuse people. But apart from administering the Act, my branch was also responsible for doing the FOI responses for the Cabinet Office and the Premier's Department. And every time I got one of these requests in, I had to take a person away from their real work and get them to deal with this FOI request. And it really, really genuinely did slow down the ability to do your proper work in government. So it's not a fake issue, it's a real issue, but the way you respond to it needs to be more sophisticated. So instead of stopping everybody by making everybody pay application fees or whatever, you need to have a more sophisticated way of dealing with it. Okay. So while record keeping may seem a small, bureaucratic and time-wasting exercise, it is integral to the big, important issues, including government accountability and integrity. As digital transformation changes the way that we keep or avoid keeping records, we need public pressure, including through ART, to ensure that the laws and procedures are in place to ensure that we retain the records and that explain government actions, and we maintain public access to them at appropriate times. And that's the only way that we can know what a government does in our name. And it's the only way that history can hold them to account. Thank you.
Take a seat and relax. I think that there's a constitutional clarion episode to be made of Anne Twomey on a cold Canberra night in commando gear outside some agency where she thinks that 12-year-old or 14-year-old request might be in there somewhere. It'll get a huge number of hits, I'm sure. We've got time for questions around 10 minutes. There'll be a roving mic. So please feel free to put up your hand. If you could just tell us who you are before you ask your question to Professor Twomey. We have the first one down here, and I'll keep an eye on others. There we go. And then gentleman there.
Anne, thank you very much for an incredibly informative discussion of some of the places where information can be squirreled away, never to be seen in the light of day again. I'm very interested in your last point about the problem of the excess of FOI requests, and I totally agree with you that just charging people more and making it harder to make them doesn't seem to be the appropriate response. And I'm not a lawyer. Oh, but I should have introduced myself. I'm Julia Thornton from Accountability Roundtable. But I have a memory of, I think it was FOI, the first FOI Act, which I think was David Solomon's in Queensland. And it kind of reversed the sort of, I suppose, onus of proof using the right to know principle. The idea that the information belonged to the people, the government was acting under the behest of the people and should automatically hand information back to them unless there was a really good reason. And I'm just wondering what you think of the right to know principle and how it could be applied.
Sure. I think I'm still on. Yes, it's a funny thing though, because you often see that in FOI Acts as well, that, that the fundamental, they'll say that the basic principle is that you have to give this stuff out. But the public servants all know that the reality is the reverse, that the basic principle is that you don't give it out, unless it's complete dross. And so that's why they just gut the files and take things out. So even though the principle is there are sufficient exemptions that can be read broadly and exploited. I mean, they did do some reforms, I forget which act it was, I think it was the Commonwealth one some time back, where again they tried to improve the act and they actually expressly said that embarrassing the government is not a reason for, it's not a ground for failing to give the document over. Yeah. But the reality is, there is huge pressure on public servants in the reverse way. Now, as I said, when I worked in the New South Wales Cabinet Office and I ran the legal branch, and we did, do FOI, and I had a stand-up, toe-to-toe fight with a ministerial advisor, and I should say, I'm this tall, he was about up there, he was a huge man, and he said, you are not releasing this document, these documents, because they are going to embarrass the government. And I just stood there and I said to him very loudly, are you telling me to breach the law? And I can tell you that really worked, because enormous man that he was, he scurried away and I never heard boo from him again. So that's my recommendation to public servants when they get put in that position, because frankly, if you say it very loudly so everybody else in the office can hear, are you instructing me to breach the law? Generally at that point, they think it's probably not such a good idea. Having said, and I should add that I was not sacked after that experience either. Having said that, however, maybe they were different times. I do know that there are many public servants these days who do fear for their jobs if they are seen to be obstructive or unhelpful. And the irony is that often it's the being obstructive or unhelpful that will save your minister's job and their reputation. Had people been more obstructive and unhelpful in Berejiklian's office, for example, you may not have had the same outcome, right? And the same in Scott Morrison's office. The reality is it's the obstructive and the unhelpful people who point out what the law is are the ones that actually save government and reputations. And this is something I do try and press upon politicians, but, what can I say? I get ignored. So anyway, a short answer to your question is, yes, it's a good principle to have. Is it effective though? Frequently not, because of cultural issues.
Gentleman over there, thank you.
Can I be heard? Peter Fitzgerald, like yourself, I'm a former public servant, but also a political activist. And I wonder about what is the most successful accountability mechanisms that we have, one of which is Senate estimates. It's also true in the Victorian Parliament that ministers having to account for the budget estimates is a very effective way of calling them to account about whether they're across their portfolio, etc. But it, in effect, is about the accounting for money spent. I wondered whether if we had an integrity subsection to estimates. So once we've done the dollars and once we've done your portfolio, we now want to talk about integrity. And what are the measures? How many of your FOI requests have been rejected? Are you across? So your suggestion about the lawfulness of rejections, you know, Minister, how often have you been told that this rejection would be contrary to the law, or your failure to respond would be against the law? So I just wonder whether you think that's an effective accountability mechanism, or are there anything similar to it that would bring them to account?
Yeah, look, I think that's really interesting. I mean, one of the other mechanisms that, you know, if you really want to scare a politician and stop them from doing something, you just say to them, how will that look on the front page of the Daily Telegraph, or add your local newspaper here for that? Or, you know, how would you respond to that in an estimates inquiry? And usually when they start thinking about that, you know, what if I am asked about this in estimates? You know, what if this is sprayed over the front page of your local tabloid? They will think differently. Okay, so that's sort of step one in this thing. My second observation, and this is one that I've wanted to do, you know, encourage for a while, is that one of the other great places for calling governments to account is Auditor General's reports. They do fantastic work because they have inside, you know, they can go and find all that, they can see all the documents, they know exactly what's going on, and they can examine people, etc. One of the problems with the Auditor General's office is that they do not have a role in terms of assessing the legality of what's going on. And so, I mean, sometimes they sort of do it indirectly, like sports rorts and stuff like that, and again with the Berejiklian stuff in New South Wales. But what they really need is also to have a legal branch in the audit office that fulfills that legal role as well. I mean, that's not quite necessarily integrity, but part of integrity is obeying the law. It's also a fairly fundamental thing for government. And I do think that Auditors General do fantastic work as it is, but they could really enhance what they do if they had a dedicated legal branch to do that work. So that's the second thing that I would do. Third thing, I think that's a really interesting idea. Estimates does scare the living daylights out of politicians. I mean, they can be used in a really abusive way. I have seen estimates inquiries and other parliamentary inquiries treat people absolutely abominably. So they can be good and bad. And when they're bad, they can be very bad. But also, as you're right, they can find out a lot of things that otherwise would not see the light of day. And the mere prospect of their existence can sometimes force governments into integrity. So, yes. And it's also the case that even though estimates committees are supposed to be focused on money, they do range far more broadly than that into integrity issues anyway. So it's sort of what they do as it is. But yes, if you had something that was a bit more structured into the integrity side of it, I think that would be an interesting idea.
We still have about 5 minutes while the microphone's finding its way to the back row first. Thank you. I was wanting to ask you, Anne, about the imploding digital messages thing. Institutional memory. Well, there's another element of the picture there.
Yeah.
And it sounds to me like this particular medium of communication is most commonly occurring between politicians and advisors as opposed to public servants. But there must be a strong exasperation on behalf of many public servants as to this informational void that means there is no institutional memory politically or perhaps also bureaucratically. Is that some of the part of the issue you have examined?
Yeah, you're right. I mean, it's not just history itself, but you know, in the past there was a file that you could go back and you could look at. So the last time we did that, this is what happened.
Exactly.
If there are holes in that, yeah, you're right. It is going to be an issue in the public sector as well.
Microphone's found a landing place.
Yes. My name's Peter Clark. I'm a barrister, but before that, I was my first job was a research officer and staffer in a member of Parliament's office in federal Parliament. And when I was working, my member of Parliament was in opposition. There was a steady stream of documents, and this is in an analogue era, of documents that would land in the office by various means from the Public Service Office, and you know they're otherwise known as leaks. What is there a correlation between the extreme secrecy you're referring to and the frustration within the public service that leads to leaks and whistleblowing? And does that actually, is that a sort of an informal? Is it a thing in your observation? We thought it was because we would get it fairly regularly. Most of it was dross, but there was occasional nugget of gold. And is it a measurable thing that assists in more transparency or trying to deal with the lid that's put on information?
Yeah. Yes, it's quite interesting. I mean, obviously, if you're a public servant, you are not supposed to leak, and it is wrong. You shouldn't, because you're there. You are trusted by the government to act in the, as instructed in the government's interests. According to government policy, not necessarily in their interests. So leaks are wrong, but are they also a safety valve? Possibly yes. I mean, maybe that is part of the democratic system. I don't know. I haven't really thought that through well enough. I wasn't ever in the system of ever receiving leaks or certainly giving leaks. Never leaked anything to anyone, at least where I was. So I guess I wasn't really in the ecosystem and seeing it, so I don't know that I've got enough experience to answer it. But the one thing I will say is, getting back to the digital age and the doing things on messaging apps, the amount of spectacular leaks there have been of them. Yes. I mean, on the one hand, people think that what they're doing is all terribly, terribly secret, and then you see a massive leak of 1,000 WhatsApp messages between, you remember at the time when Malcolm Turnbull was being challenged by Peter Dutton, and there were sort of issues as to whether Scott Morrison or Peter Dutton or, and Julie Bishop wanted to run or whatever, and there was all these WhatsApp groups that were all sort of, ganging up against each other, and all of that leaked. And you remember Mike Pizzullo and all his messages, etc. I mean, somebody somewhere had them and managed to leak them all to the media, and you do have to wonder, given that he was in a defence sort of area, whether it was a foreign country that did it. Yeah. So the level of security with these messaging apps is not great. So in terms of the prospects of leaks, it's probably easier to leak those messaging apps than it was in the old days with the analogue documents. Yeah. But anyway.
We've got time for one more short one. Gentleman here, thank you. If we could just keep it short so we have enough time to wind up.
Fred Allen is a former public servant. I wonder whether part of the problem is the very low status and priority that record keeping is conducted in public service. The people doing the actual work and collecting the data, they're at the bottom of the ladder.
Yes, I think it's a short answer. It's not respected, and it's particularly not respected by politicians. They just think that that's some irrelevant thing that someone else should deal with. You might remember when Tony Blair came to office in the UK, it was all about, what do they call it? Sofa government or something about sitting on the couch and making decisions, and we're not going to deal with this old formal let's sit around a cabinet table and have everything recorded. And then they soon realised that sofa government without proper records is a complete debacle. And they, the next government came in and said, no, we're restoring proper cabinet processes. So process in government is actually really, really, really important. It's often disrespected by politicians until things go awry, and suddenly they realise, oh, actually, process is a good thing after all.
Yes, exactly. What a lovely point to end on. We're going to just bring up Stuart Hamilton from the ART to give the vote of thanks to our wonderful speaker tonight.
And that was a fantastic address. Thank you very much for your feistiness, whether in front of large ministerial advisors, large-bodied but small-brained ministerial advisors, or just the way you were speaking sharply about these issues, which can sound dry as dust when presented in some circumstances. You made it very clear how central to the whole business of integrity and accountability is access to information. I loved your homage to Hannah Arendt, the banality of corruption. I think that was a great start, but the whole discussion that you led, I think, made us all remind ourselves of how important it is. And you've had practical thoughts about how to cope with the endemic nature of government protectiveness of information. It remains a huge problem. We know there are possible solutions, and the one you mentioned of reversing the onus that Julia asked you about, yes, governments will find a way around all of those things. I myself, you started off in the analogue era, and if I can, for 30 seconds, tell a story of my own, I had my fingers, unfortunately, rather too close to the sports rorts. Right. I was head of the department when the minister was found out. Not when she devised it, I have to say, because she didn't devise it. And this story I can only tell now that a certain famous whatever it takes politician is dead. With Richo dead, I can safely say when Ros was sent packing, Richo became the acting minister. And I was head of the department, and I said to him, well, the Senate Estimates Committees are still meeting. You, of course, Minister, I didn't remind you, not only are part of the government that Mrs Kelly was part of, but you actually devised the sports rorts scheme. So when there'll be a few senators who remember this, how are you going to handle it? The simple, Stuart, is that I'm going to say, yes, I did it, and so will you. Next question. And he did. And they all laughed and went on to the next question. Oh, so that whatever it takes approach, that was 30 odd years ago. Yep. He was the master of it, if you like. Now dead, but you know, I think we have different means in the digital age, but there were plenty of means in the analogue age too to avoid information. I think it's probably harder now for the reasons you mentioned, but it's still happening. I'd like to thank you for that. I'd like also to thank Melbourne Law School for co-hosting this event, to thank our sponsors, both the McKinnon Trust, who have made a generous donation to enable us to professionalise ourselves. That's fantastic. Also, more pointedly for this evening, where we're about to invite you to have drinks.
Yes, we are indeed.
Muraduck Estate is sponsoring us by providing some splendid wine. But before that, I will ask Anna should come with me and take from our patron, Barry Jones, a gift.